Estate planning for adult interdependent partners. Similarities and differences. Estate planning for adult interdependent partners is fundamentally shaped by Alberta's Adult Interdependent Relationships Act, which grants non-married partners many of the same rights as married spouses. The primary similarity lies in the default safety net provided by the Wills and Succession Act in the event of intestacy. If an adult interdependent partner dies without a will, the surviving partner is generally entitled to the entire estate if there are no children, or if all children are also the children of the surviving partner. This mirrors the treatment of married spouses, ensuring that a long-term partner is not left destitute simply because they never had a formal wedding ceremony. However, the legal definition of an adult interdependent partner is more complex than marriage. It requires either 3 years of continuous cohabitation, a relationship of some permanence with a child, or a signed adult interdependent partner agreement. One of the most significant differences between adult interdependent partners and married couples involves how the relationship is legally established and, consequently, how easily it can be challenged by other heirs. While a marriage certificate provides indisputable proof of a legal union, an adult interdependent partner's status often depends on a fact-specific analysis of whether they functioned as an economic and domestic unit. This can lead to litigation from siblings, parents, or children of the deceased who may argue that the relationship did not meet the 3-year threshold or lacked the necessary level of interdependence. For estate planning, this means adult interdependent partners must be much more diligent in documenting their status through a formal agreement or a clear, well-drafted will to prevent costly and stressful court battles over their standing. When it comes to the revocation of existing wills, the rules for adult interdependent partners differ slightly but crucially from married spouses. Historically, marriage would automatically revoke a previous will in Alberta unless that will was made in contemplation of the marriage, but current laws under the Wills and Succession Act have changed how gifts to ex-partners are handled. If a couple enters into an adult interdependent partner agreement, it may impact a prior will similarly to marriage, yet the mere passage of the 3-year cohabitation mark does not typically revoke a will. This creates a risk where an individual might have an old will leaving assets to a parent or sibling, and even after 5 years of living with a partner, that old will remains valid. Married spouses and adult interdependent partners both need to update their plans, but adult interdependent partners face a higher risk of accidental disinheritance due to the gradual, often silent transition into their legal status. Property rights upon death have become much more aligned since the Family Property Act was expanded in 2020 to include adult interdependent partners. Previously, only married spouses had a clear statutory right to an equal division of family property upon the death of a partner, while common law partners had to rely on complex, unjust enrichment claims. Now, a surviving adult interdependent partner has the same right as a spouse to claim a division of family property against the deceased's estate, ensuring they receive their fair share of assets acquired during the relationship, regardless of what the will says. This is a powerful tool for protection, but it also means that both spouses and adult interdependent partners must use tools like cohabitation agreements or prenuptial agreements if they wish to keep certain assets, such as a family business or an inheritance, separate from their partner's potential claims. The Dower Act remains one of the few areas where married spouses hold a distinct advantage over adult interdependent partners in Alberta. This specific legislation provides a surviving spouse with a life estate in the homestead, meaning they have the right to live in the home for the rest of their life, even if the home was owned solely by the deceased spouse and left to someone else in the will. Currently, these dower rights do not extend to adult interdependent partners. While an adult interdependent partner can still make a claim for maintenance and support under the Wills and Succession Act to stay in the home temporarily, they do not have the same automatic, lifelong protection that a married spouse enjoys. This makes it vital for adult interdependent partners to specifically address the family home in their estate plan, perhaps by using joint tenancy or a specific life interest clause in their will. Finally, the concept of dependence relief applies equally to both married spouses and adult interdependent partners, serving as a check against unfair disinheritance. If an individual dies and fails to provide adequate maintenance and support for their partner in their will, the surviving adult interdependent partner or spouse can apply to the court for a larger share of the estate. The court considers similar factors for both, including the length of the relationship, the surviving partner's financial needs, and the size of the estate. While the legal pathway is the same, the evidentiary burden can be heavier for an adult interdependent partner, who may first have to prove they qualified as a partner before they can even argue they were inadequately provided for. Consequently, while Alberta law strives for equality, the lack of a marriage license means that adult interdependent partners must be more proactive in their estate planning to achieve the same level of certainty and security. For more information about our law firm's legal practice in relation to adult interdependent partner agreements and estate planning matters for adult interdependent partners, we welcome you to visit our website and contact our law firm to schedule a confidential consultation. Thank you.